Perfect. Thank you so much for having me come and talk to you. I've been to New Mexico lots of times, but this is the first time I've ever tried it this way. And frankly, I think of the two of us, my wife is the most upset because she likes her green chili and she likes to get it there. So when we drive down there, and we usually drive, that's what we do. When Kelly asked me to do a presentation, she asked me to do what I call my fundamentals presentation. It's legal and historical foundations, but I call it the fundamentals. And the fundamentals basically is a presentation that goes to states and says, hey, bail reform is coming. It's inevitable. And by the way, bail reform kind of looks like this. It looks like what's happening is that money's going away, at least as a detention mechanism, and what's replacing it seems to be this on-purpose in or out sort of process. But I realized this doesn't work so well. I go around the states in America and scare people saying it's coming, get ready. And I try to tell them how to get ready. But you guys have already made really big changes in this generation of bail reform. So I thought, well, this doesn't work at all for you necessarily. And so then Kelly said, well, there'll be lots of judges there. And I said, well, I've done this before. I've talked about judges in the generation of bail reform. And I didn't think that would work either. And then I was getting loopy and I came up with all kinds of crazy things. And finally, I decided to stick with this one, a brand new sort of a presentation. It focuses mostly on New Mexico in this generation of reform. I'm going to call it that New Mexico is special and historic, because you are. But being ahead of the curve is just not that easy, and you'll understand why when I get to that point. And the way I'm going to show all this is I'm going to basically say that we've done bail in the American states a certain way since about 1830. But all the states are changing. In fact, what I used to tell people was it's inevitable that you'll change. Now, ideally, when we see bail reform in the states, we see three phases of bail reform, and you almost have to have them all for it to work well. And the first phase is education in what I call the fundamentals of bail. And the fundamentals of bail, like I said, tend to tell you that bail reform is inevitable. It seems to point away from monies being able to detain people pretrial. And then there has to be some pressure. We've noticed that across the country, some pressure has to be sort of exerted. And that ends up leading to a state creating what I call a new model. Now, when I use the word model, realize I'm not talking about this is the model, this is the one you want to use. I'm saying it's just your model. So realize in New Mexico, you had a model of release and detain prior to 2016. You came up with a new model in 2016 and 2017. So your model is what it is now. I have a model. DC has a model. The federal system has a model. Every state has a model. Usually this education and pressure leads to changing your model. So what I'm going to do is focus on these three things. And I'm going to focus broadly at first on how I teach these things across the country. What are the fundamentals? Why are they important? What's that pressure look like when it comes? And what do we do with our model? And then we're going to turn the corner near the end, and we'll talk about New Mexico and ask ourselves, are you finished? Are you comfortable with your model that you've done? Now, I want to give you a couple of reasons why I think you ought to watch, because, some people don't think they should. Maybe they should. I don't know. But I guess what I've learned is that knowing these things, these fundamentals of bail and some of these other notions, really helps you to understand the forces that are at play in America causing all this change. It's nothing that I made up. This is just documenting the history and the legal foundations. Also, knowing some of this information will actually help with bail setting. So to the extent you're in a place where you're actually doing bail, it'll help you set bail. Mostly, though, I think the main thing is it's going to help you figure out how to assess your comfort with your model, whether you're comfortable with this model or uncomfortable. And obviously, prior to 2016, you were uncomfortable with the model you had and you felt the need to change it. Now you have to ask the same question. Are we still comfortable? Are we not? And then finally, I would just say, I would be curious if I were you. I've been given this exact same message now for 15 years, back when there was only about 5 of us that were doing any kind of thing with bail. And it's led to a heck of a lot of change. And we've kept up and we think we know a lot of what states need to know to make sure they're comfortable with how they do bail. And I'm going to go through what I call the story of bail in America. And to tell the story of bail, sometimes I have to go back a little bit of time. But because it's a story, it all kind of fits together. And so what I hope you'll let me do is go for about an hour and 15 minutes. And I'll just tell the whole story. And if you have questions, write them down or put them in the chat box, and we'll have, I guarantee you, we'll have 35, maybe even 40 minutes at the end to discuss questions. We had plenty of time yesterday, and it seemed to work really well. Yes,
Tim,
Cecilia.
real quick. So we're actually only seeing your first slide on your presentation.
That's not good.
I know. I was like, what is happening? Unless it's just me. If anyone else is different, please speak up.
No, I'll do it again. I'll go to this one.
So we're slide 7 now, but it shows your whole PowerPoint window, not just the slide.
Hang on. Okay. Are you seeing a different slide now?
Yep, that's perfect.
So we'll just go back and do a very quick thing. I said, this is what I'm going to do. I'm going to call it this. Do you see a flag?
Yes, we see it now.
And how I'll show it is I'm going to talk about how things are changing. I'm going to talk about these 3 phases of bail reform, which deals with education, pressure, and a model. I'm going to do that as the story of bail sort of unfolds across America and how we talk about it. And then I'm going to turn the corner and talk about New Mexico. And the reasons you should watch, like I said, is to understand these forces that are leading to bail reform in America, to help with bail setting, and mostly to have comfort with your model. States across America are having discomfort with their models, and they're making changes. And so if you have discomfort, it's good to be able to articulate it. So to study bail, I'm going to tell the story of bail. And what I hope to do is to get it done in about an hour and 15 minutes, and then leave plenty of time for questions. So like I said, you can put them in the chat box or wait till the end, but it's helpful. I've noticed when I tell the story of bail, sometimes if a question comes in the middle, it's answered later because the story unfolds as we go further. Does that make sense? So let's talk about these fundamentals of bail. I like talking about the fundamentals of bail because right off the bat, it tells me about this phrase here, legal and evidence-based practices. This is code for bail. Anytime you see this, you know you are working in the pretrial phase of the case. This was coined by someone named Marie Van Nostrand in 2007. And she was trying to see if you could take post-conviction research and apply it to the pretrial phase of the case. And she said, well, you kind of can, but not really because of all these legal principles that kick in. And so she said, really, in pretrial, we don't do just evidence-based practices. We have to worry about the law too. And so she coined this term, legal and evidence-based practices. And I called her and said, this is fantastic. I love this phrase because it sums up everything I do. Anytime I look at anything in bail, I say, is it legal and does it work? And these things are also interconnected, you see. Sometimes something can work really, really well, but the law is going to step in and say, you can't use that because it's unfair. Now, I like this phrase so much that I used it to name my nonprofit after it. That's how much I like it. Nobody can pronounce this nonprofit, but I used it to make a point. Now, people ask me, okay, what do I need to know? I want to do legal and evidence-based practices. What do I need to know and why do I need to know it? And I say, you need to know the fundamentals of bail. The fundamentals of bail are just simply 6 big subject matter areas, and you need to know each one in equal measure. But if you know them, you can do anything. You can do anything from recommending a condition to a judge all the way to change your constitution. They're helpful in all those things. Now, the good news is you don't have to write them down because I've already written them down. I wrote 2 papers for the Department of Justice. The first is called Fundamentals of Bail, and it just lists all the fundamentals and discusses them in their application to bail. 6 big subject matter areas. But then I wrote a second paper and I said, you know, I'm going to write this for judges. If you were to follow the fundamentals of bail, how would you set bail? And that paper has more footnotes, more sites. It's a lot more sort of a legal paper. And it turns out the answer is that if you're going to follow the fundamentals of bail, bail is going to be an intentional in or out decision, immediately effectuated with nothing standing between the in and the out. Now, because I wrote that in both papers, I had to drop a footnote though. And I said, by the way, states, if in fact you want to do that intentional in or out system, you're probably going to have to change all your laws. And I just left it at that. So what are the fundamentals? Well, here they are. Why change it all? Knowledge of the problem is helpful to know. History of bail, legal foundations. We're going to cover those a little bit today, so you'll see. Pretrial research is incredibly important. And as I'm going to stress later, what I call the risk research, defendant risk research that goes into our defendants risky. What's this stuff with actuarial tools? I think that's crucial for everyone to know in order to be comfortable with your model. It's a fundamental of bail, the research. National standards, we have two sets, the American Bar Association and NAPSA, the National Association of Pretrial Services. I won't talk about those today. Terms and phrases. And by the way, terms and phrases, this is the reason why NIC asked me to write the paper. Because they came to me and they said, you know, Tim, we go across the country and we talk about how do we achieve pretrial justice? And we're sitting at a big table and there might be 40 people there and they're from all across the country, different states. And we're asking that question and inevitably someone raises their hand and says, I know how to achieve pretrial justice. Let's eliminate bail. And if you're lucky, someone down the way, I'll say, oh, wait a second, we can't eliminate bail in my state. We have a right to bail. It's in our Constitution. What's the problem? Well, the problem is they're defining it differently. And you can't have a national movement of any kind if we can't even define our terms and phrases, big terms such as the word bail. It turns out that the good news is if you follow all these other fundamentals, they point to universally true definitions of terms and phrases. I call them the legal and historical definitions. The legal and historical definition of bail, it turns out, is that bail is a process of conditional release. Why do we have bail? We have bail so that we can have a mechanism to release people. Why do we have no bail? We have no bail to provide a mechanism to detain people. I'm going to use that as my definition today. And so anytime I point to the word bail or no bail, I want you to think release and detain. Now you're at an advantage in New Mexico because somebody figured this out already back in 2016 and 17 when they started replacing the word bail with pretrial release. Now the big issue that I go around the country and talk about, which everybody faces, is money. It's been a problem for a long time. And it's not just every kind of money. It's really only one brand of money, which is called the secured financial condition. The secured financial condition basically says you have to pay something in advance to get out of jail. Security. Could be cash, could be property, might be a fee to a bail bondsman, could be the 10% option. I've just worked in Illinois recently. And this is the fundamental issue at bail today in the American states. And it's been a problem for a while. And in fact, you can tell it's a problem simply by holding it up to the other fundamentals. We didn't really start using secured financial conditions in America in earnest until about 1900. 1900, we started using them more and more, and they've been flawed ever since. Money is the thing that's going to bring the people to your state to sue you. People are suing in federal court, and we'll talk about that in a little bit. The research says it doesn't really work, and the standards say you shouldn't use them. And in fact, secured financial conditions cause problems at both ends of the spectrum. Now, I didn't make this quote up. This came from the New Jersey Supreme Court. Chief Justice Rabner got together a group several years back and said, we're going to study bail and no bail, release and detention. And they came up with recommendations. And on the very first page, it said, by the way, these secured financial conditions cause problems at both ends of the spectrum. And the first end is illustrated by this guy. This is Leslie Chu. Leslie Chu is someone we might call today a low-risk defendant. He didn't really have a criminal history. He had a job. He had a car. Now, he was poor. He lived in his car. And he was working in West Texas. He was working in the oil fields. And one night it got cold and he went to a store and he shoplifted a blanket. Well, he got caught immediately. And I don't know if they took him to a police station or if he saw a judge, but his amount of money, his secured financial condition to get out of jail was $3,500. Well, he didn't have that. He didn't have $350 to pay a bondsman, or I suppose he would have bought the blanket. So he stayed in, and he stayed in about 8 months. We have his picture because NPR did a story on him, but I put this picture up here because it illustrates this end of the spectrum. This happens all across America. But this also happens. Maurice Clemens assaulted a police officer. He went before the judge, and the judge said, this is very serious. I'm going to set your financial condition of bond in secured form at $30,000. But Maurice had money. He knew a bondsman. He got out. Within a week, they arrested him again. This time they claimed he tried to rape 2 small girls. And so the system said, holy smokes, we need to interview him. We need to assess him. And they went back to the judge and they said, Your Honor, this guy is highly likely to reoffend. He's incredibly dangerous. We think he's going crazy. He's talking to himself. His family's all worried. And right at that moment, I suppose the judge did what judges have done for a long, long time in America. And maybe this judge thought, well, $30,000 didn't do it. I'm going to set the financial condition of bond at $180,000. But Maurice had money. He knew a bondsman. They actually got a deal on the front end, and he got out. And within a week, he went to Parkland, Washington, and walked into a cafe and shot and killed these 4 officers. So we have problems with bail or release and no bail, which is detention. And it's both based on how we deal with these things called secured financial conditions. Money seems to be the fundamental problem at bail in the states. But it's such a part of our culture that, like I said, some states define bail as money. And of course, we have a giant lobbying group keeping it alive. The question is, though, does it have to be that way? And the answer is no. And I know the answer is no because I know the history of bail, which is a fundamental of bail. What I like about the history of bail is it helps you understand bail reform. Because if you understand bail reform, you know how we get into eras of bail reform. Right now, we're in a generation of bail reform. You'll know how to get out of bail reform, and you'll know how to avoid bail reform in the future. So it's helpful to know that. And to understand bail reform, all I have to do is take you back to 1274 in England. Back in 1274 in England, you were either bailable or you were unbailable based on custom. So it's like our common law. And it's appropriate to look at English law because all of our bail laws came from England. And this was the king, Edward I. You may recognize him. He was in a movie with Mel Gibson. Edward I had heard rumors that bail was being done poorly in his land, so he sent out 100 inquisitors. And he said, go out across my land, find out what's going on. And they came back and they said, Your Highness, things are bad out there. And he said, what's going on? And they said, well, you know, the sheriffs are your bail setters, right? Yeah, sheriffs set bail. Well, there's people showing up on the sheriff's doorstep and they're customarily bailable. But the sheriffs are saying, hey, I know you're customarily bailable, but I'm not going to let you out of jail unless you give me some money. Other people are showing up on the sheriff's doorstep and they're customarily unbailable. And the sheriff's looking at them and saying, yeah, I know you're customarily unbailable, but I'll let you out of jail if you give me some money. Well, everybody was upset. I like to say the king was royally ticked. And so Parliament passed the Statute of Westminster in 1275. And the Statute of Westminster said, okay, from now on, there's no more custom. You're either bailable or you're unbailable based on the statute. And if you're bailable, sheriff, you have to release them. Bail means release. And if they're unbailable, sheriff, you have to detain them. No bail means detention. And you can't take any money. And if you screw this thing up, sheriff, pursuant to the statute, we'll put you in jail. The Statute of Westminster created the first legislatively articulated bail, no bail dichotomy. You're either bailable or you're not. Now that's really, really important because today, everywhere you go in America, we find bail, no bail. Usually, all I have to do is open up your Constitution to find everybody's bailable except no bail. But that's not the thing that helps you understand bail reform. The thing that helps you understand bail reform is that secondary notion that bail was always supposed to lead to release, just like no bail is mostly supposed to lead to detention. In fact, that's such a big rule that historically speaking, when you go back in time, you see time and time again that if anything gets in the way of bail is release or no bail is detention, you see bail reform happen. Now, every so often it happens with no bail. Every so often, somebody looks at the no bail bucket and says, well, we think these people should be in the no bail bucket, or we should add this or that new procedure to it. But mostly it happens over here with bail or release. So much so that as a rule of thumb, you can almost guarantee yourself, if you're looking at the long lens of history, that anytime you see bailable defendants in jail, bail reform happens. And this is how we've gotten some really big reforms. We have habeas corpus because bailable defendants were in jail. We have the rule that prosecutors have to charge you because bailable defendants are in jail. Bailable defendants in jail leads to bail reform. Now, back in the old days, we did no bail the same way we do it now. We lock you up. We think we do it better now, but basically it was the same. But back then, we did bail or release completely differently. Back then, to release somebody, we used the personal surety system. What's that? Well, that's where the sheriff would have to go find a person, a surety. Maybe he'd find 3 people. Maybe this guy looked kind of dicey, and so he'd say, I'm going to have 3 people watch over you. So we'd find 1 or 2 or 3 sureties. That person had to agree to take responsibility over the defendant under what we call today a continued custody arrangement. And third, they weren't allowed to make any money. This was too solemn of a duty. You weren't allowed to profit from this. In fact, if you ended up shelling out any kind of money at all as a surety, for any reason whatsoever, you couldn't allow, and nobody could pay you back. You couldn't be what we call indemnified. Money simply wasn't allowed, except in that little thing that we call today your financial condition of your bond. Now that had always been there. Ever since 400 AD, when we have the first antecedents of the bail system that exists today, there's always been something that sort of hangs over the head of the accused to make sure they come back and face justice. Now, before money, it was property. And before property, it was actually people. After money, if there's such a time, it'll probably be something else, like the threat of new charges. But get this, for hundreds and hundreds and hundreds of years, all through the history of England, all through the history of America, up until the 1800s, this financial condition of bond had only ever been what we call today an unsecured financial condition. What's that? It means you don't have to pay anything to get out of jail. You merely promise to pay an amount in the event you fail. Either you pay it or the surety or both of you. You promise to pay. That's how we could say that everybody who's bailable gets out of jail. That's the big rule. Bailable defendants get out of jail. And the way we did it back then in England was we used personal sureties, which were plentiful, and unsecured bonds. And when we moved it to America, we said, this is fantastic. We're going to use all this stuff. Bail is release, no bail's detention. We use these personal sureties. We won't allow profit. We put it in our laws. And then we're America. You know, we stand for liberty and freedom. And so there's some parts of the English system that we're going to change. So we made 2 or 3 big changes in America to bail. First thing we did was we really enlarged the bail part. The right to bail got bigger and bigger. No bail got smaller and smaller. Eventually, it was everybody has a right to bail or release, except for capital offenses. And then we started chipping away at the crimes that were capital crimes. The second thing we did something that I like to call bright line bailability, or being bailable up front. All that means is that we lay out all the charges and we say, if you're bailable, you're going to be released. It's the way it started in England. Why did we have to do that? Well, it turns out in England, what happened was after the Statute of Westminster was passed, after several hundred years, some discretion started to seep into it. And the discretion was like this. In a certain number of cases, very few, but some, a judge could actually decide in advance if you were bailable or not. Well, it's easy to have a rule that says you have to release all bailable defendants if you get to decide who's bailable or not. That's the discretion America didn't want, and they said, we're taking that out. We're going to make it so you know what the bailable charges are, and you'll know you'll be released. It's based on notions of due process, fair notice, letting people know in advance how to stay out of jail. And the third thing we did is a thing I call the further limiting process. Because in America, we said, hey, just because you land in the no bail bucket, yeah, maybe you don't necessarily need to be detained. So we're going to add a further finding, another thing in there that the judge is going to have to find to keep you in there. The first one we ever saw was proof evident presumption grade. So the first bail clause you might have seen would be everybody has a right to bail except capital defendants, but only when the proof is evident and the presumption great. If it's not evident, not great, even those people would be released. America made it so that every single person could theoretically be released. There was no automatic detention. So when you looked at a no bail provision in America early on, you knew that it was that state's articulation of who it could detain upfront on purpose. And back then it was based on prediction of flight. That's the only thing we could care about or look at. This is important. Every no bail provision that's out there is made up of two things: the detention eligibility net, which means you're in the no bail bucket, and a further limiting process, which is just the way America decided to do it historically. This whole thing worked phenomenally well in America, by the way, right up until the 1800s. In the 1800s, a funny thing happened. We started running out of those personal sureties. It's just, people didn't want to do it anymore for no money. So what's that cause? Well, that causes bailable defendants to be in jail. What's that cause? That leads to bail reform usually. So something had to give. And it happened in England and America. And what they did in England is they said, well, let's pass a law and allow judges to release people with no sureties. And that's what England did. But in America, we went a different route. In America, we said, why don't we chip away at those laws that say you can't profit from bail? Let's chip away at those laws that say you can't be indemnified at bail. So what we did in America is we moved to the commercial surety system right about 1900. Now realize we did this to help get bailable defendants out of jail. They couldn't get out because there were no personal sureties. We moved to this system to get them out of jail. But when we moved to this new system, we did something that I don't think we saw coming. And that's that we changed the nature of the financial condition. Because remember what I said, for hundreds and hundreds and hundreds of years, all through the history of England and America, this financial condition of bond had only ever been what we call an unsecured financial condition. Well, now under this new model, if we used it a lot, it was mostly going to be a secured financial condition, meaning someone's going to have to pay something to get out of jail. What's that cause? Well, again, it causes the same thing. We have defendants that can't get out of jail because they don't have personal sureties. Now they can't get out because they don't have that. Plus, they don't have the fee to pay a bondsman, or perhaps the bondsman walks by and doesn't help them for no reason. It causes interference with bail as release. And I said that always leads to bail reform. So we have what's called the first generation of bail reform in America. Now, why don't I call that earlier thing a generation of bail reform? Nobody does. No historian, no legal scholar ever says that moving from personal sureties to commercial sureties is a generation of bail reform. They just don't do it. Why is that? Well, I'm convinced it's because it never worked. It simply didn't work. In fact, it might have made it worse. All I know is our first commercial surety entity started in 1900. And by the 1920s, we start to see documents by really smart people. People like Roscoe Pound and Felix Frankfurter saying, oops, we've made a mistake here. And so in this first generation of bail, we spent decades once again trying to figure out how to get bailable defendants out of jail, focusing primarily on release. Now, we had a second generation of bail reform too, and this is interesting. There were people getting out on bail, but they would commit a crime. And a group of folks said, well, we don't want them out on bail. We want them in the no bail bucket. And a second group of folks said, well, how are you going to do that? And the first group said, we're going to make a prediction that they're going to commit a crime, and based on the prediction, we'll put them in the no bail bucket. And the second group said, that sounds un-American to me. That you're going to stick me in jail for something you think I may or may not do. And by the way, more importantly, public safety is not even a valid consideration at bail. All you can really consider at bail is court appearance or flight. Public safety has nothing to do with bail. Well, this generation had all those questions. They were good questions, and they were all answered by the Supreme Court in the second generation of bail reform. It turns out you can do all those things. You can enlarge your no bail bucket. You can put people in there based on prediction of something they may or may not do in the future, and you can base it on public safety in addition to flight. Mostly in the federal system, we worked on detention, but we also worked a little bit on release. And in the second generation of bail, I actually coined the term the big fix that we did in America. You don't have to know what these terms are, because later I'll tell you what unintentional and intentional detention are. But just realize after the second generation of bail reform, the federal system and DC with it tried to fix everything. They tried to fix all kinds of detention by moving away from money and moving toward an on-purpose, in or out, release detained system. Well, we had 2 generations already. Why in the world do we need a third? We're in the 3rd generation of bail reform right now. Well, like I said, those first 2 generations were federal reforms. DC did it too, because they're basically tagging along. But no state went all in on the big fix. They cherry picked. You can find things from each generation in every state. Well, plus we have new research, really great research. You know, most of our bail in the past has been based on what your charge is. We look at your charge and we make assumptions about how risky you are. Now we have all this research. It says that's not the best way to assess risk. And we have better historical research and legal research. We actually know all the solutions. But I'm convinced that we're in this 3rd generation of bail reform because we still allow money to get in the way of bail is release and no bail is detention. And when you look at the whole thing historically over the long lens of history, you see that that always leads to bail reform. So what do? Well, when we go to states, we help with their bail, no bail dichotomy. We go in and find out, who do you want to release? Who do you want to detain? It's not always an easy process. But once they figured that out, then we do what we call legal and evidence-based practices to do bail and no bail. And we know what those are and we know how to make them work. Point of this, though, is understanding bail reform. I don't go anywhere and say you have to release everybody. No, both bail and no bail are okay in America, but only if you do them right. And it turns out we haven't been doing them right for a heck of a long time, and that always leads to bail reform. So let's take a quick turn, and I'm going to go over some of another fundamental of bail called the legal foundations. You've gotten a little bit of history. Here's a little bit of the law. First, I'll start with 3 quick things. One is the history and the law are completely intertwined. So if you already know the law, learn the history because it'll help you understand the law better. Well, that just follows from what I said about the fundamentals. It's important to know each one in equal measure. The second thing is that how you do bail in New Mexico is going to be based on all these sources of law. And your mix, as I call it, is going to be different than every other state. This is important because I get a lot of states, they'll call me and say, come out and tell us what New York did. Tell us what Illinois did. Tell us what New Jersey did. For a while, tell us what New Mexico did. And I'll say, I'll tell you what they did, but your mix is probably different than their mix. In fact, New Mexico is unique in a lot of cases because you do bail mostly through court rules. That's really different than the states that have to do it through statute. So just the point of this slide is realize you need to know your own mix, of course, but it's helpful to know other people's mixes to see if you can actually do what they can do. The third is that the law is incredibly sparse at bail. You know, we have like 6 billion cases in sentencing in the Supreme Court, and guess what? We only have 2 in bail. Well, you'd think they'd be so important with only 2 cases that we'd memorize them and hang them up on our walls, but in fact, we often ignore them. And I'll give you a couple of examples. The first deals with individualization. I'll give you a rhetorical question. Who here believes that criminal justice should not be arbitrary? Yay, we all do. How do you make things non-arbitrary? Well, you have standards. If you have standards and they've been crafted well and they're objective and lawful, then when you plug people into the standards, the treatment that they get is okay. The death penalty in criminal justice is the classic example of this. The Supreme Court has said that the death penalty can never be done arbitrarily, and therefore they have lots and lots of cases looking at state standards for implementing the death penalty, mitigating circumstances, aggravating circumstances. Well, bail is supposed to be the same way. In 1951, the US Supreme Court said because the function of bail is limited, you have to have standards, and those standards have to be applied to every single defendant in every single case. And when the Supreme Court said that, every single state said, oh, we know what you're talking about. And they implemented what I call the factors. Everybody's got them anywhere you go. You have them in your law. They say something like this: in every single case, the judge shall consider the following factors when setting bail: criminal history, community ties, etc. We had 16 in Colorado. In every single case, the judge shall consider the following 16 things, shall consider. But guess how we did bail in Colorado? For decades, we used a bail schedule. Anywhere you went, come up to the jail, and there's a piece of paper on the door that has a charge and money, charge and money, charge and money. What about the factors? We ignored the factors. What about the case? I'm not sure anybody really knew it existed. I didn't. What about that bigger notion that criminal justice is not supposed to be arbitrary? Well, the good news is the more we talked about these notions, these concepts, now we've become a state that's pretty much getting rid of bail schedules and moving towards a more individualized bail process. But there's a lot of states that still even mandate them. But this actually happens more often. Remember I said in the second generation of bail reform, the Supreme Court said you can enlarge your no bail bucket. You can put people in there based on prediction of something they may or may not do in the future, and you can base it on public safety. Well, because that was practically un-American, they said, you know, that is kind of a big deal. We're basing it all on prediction. You need to make sure that you do two things if you do that. The Supreme Court in 1987 in a case called Salerno said, if you do this on purpose detention stuff based on prediction, you got to do two things. One is it's got to be really, really limited. What's that mean? They use the phrase carefully limited. And if you read the case and the opinion, you'll understand, or there's other cases that talk about it, and I talk about it at length in my papers. It just means you're just not supposed to use it for everyone. Most people are supposed to be released. The detention process is supposed to be limited in the sense that you don't use it very often. Second, because it's based on prediction, it's got to be really, really fair. What did they mean by fair? Well, they looked at the federal statute and they said, we like this. This has got a full-blown adversarial hearing before you detain someone on purpose based on prediction. Has lawyers present, allows you to proffer evidence, you cross-examine witnesses. But guess what? I can walk into a courthouse anywhere in America and watch someone get detained in about 5 seconds with no due process. All it takes is for someone to mention some amount of money that that person has to pay, and there's no hearing or anything, and they're in jail with no due process. So right about now, if I were there with you, I might start to see the head scratching, and you might say something like this. Now, wait a second, Tim, this is getting out of control. First of all, you tell us a rule of thumb of history is that if bailable defendants are in jail, bail reform happens. I go, yeah, that's right. And now you're starting to show us that there's certain instances where it looks like if bailable defendants are in jail, there might be like legal problems with that. Yeah, that's right too. I don't get it. We've had bailable defendants in jail in America for as long as I can remember. When I was a little kid, I sat on my grandfather's knee and he talked about sitting on his grandfather's knee, and he talked about how many bailable defendants they had in jail. There's no way it could be unlawful because we've been around so long. You would think by now the judicial system would have fixed it. How can it possibly be unlawful? To understand why it is we have bailable defendants in jail, and yet it's taken so long to get to bail reform in America, you have to understand this concept. Now, this is the last time I'll go back in history. To understand the excessive bail loophole, I just have to take you back to the 1800s again in America. You remember I said we ran out of personal sureties. And I said something had to happen. We had bailable defendants in jail. We needed to change. Something needed to get fixed. And I said eventually what we did was we moved to the commercial surety system. Well, guess what? It took about 70 years to do that. So in between time, we tried some other things. One of the first things we tried in America is we said, why don't we see if the defendant can pay this amount of money that he used to just promise to pay? Let's see if you can pay it up front. So it was the first use of a secured bond. They called it self-pay. We didn't have the word secured and unsecured, so they called it self-pay. And what they found is that defendants couldn't self-pay. And so a whole bunch of them started to argue, and these arguments went up to the appellate courts, and they were all the same. They said, this is unconstitutional. I have a right to affordable bail. how can it possibly motivate me to come back to court if I can't even make it? And right at that moment in the history of America, the excessive bail clause of the US Constitution or of any state could have swooped in and said, you're right, it has to be affordable. And if that happened, I wouldn't be here today because all of the bail systems across America would have been built up around this core concept. But that's not what happened, is it? No, it went the other way. Everywhere they went, every single case, judges said, it's not necessarily unconstitutional just because you can't afford it. You've heard it said like this: you don't have a right to bail you can make. Well, what makes it a loophole? What makes it a loophole is that those cases, the cases that say you don't have a right to bail you can make, only deal with what I call unintentional detention. What's that? Well, it works this way. I'm a judge, I see you're a bailable defendant, I'm going to set your bail. I know what bail is. It's a process of conditional release. So I'm going to sign a release order. I'm going to set some conditions. First condition, come back to court. Second condition, check into pretrial services. Third condition, pay $6 million in cash. And then I might say something like this: I really hope you get out of jail. I really want you to be released. It's just that the $6 million in cash gives me reasonable assurance that you're going to come back. Without that, I don't have reasonable assurance. But I want you out. When that happens, the excessive bail cases say that's okay. And the resulting detention is just an unfortunate byproduct of a conditional release system. But these cases don't apply to intentional detention. How does that work? Well, it can work a couple of ways. One, a judge can look at you and say, I see you're bailable, but I'm not going to set your bail. Reversed, immediately reversed. Everywhere you go. In fact, this is such a easy case, and it happens so frequently. I usually go back into the 1800s to find it in a Supreme Court. Okay, judge learns his lesson and says, okay, I'll set your bail. And I know what bail is, so I'll sign the release order, and you'll come back to court, check into pretrial, and pay $6 million in cash. And then the judge says this on the record: and the reason the $6 million in cash is there is because I don't want you to get out of jail. I hope you can't make it. I'm worried about public safety and court appearance. Therefore, I want you to stay in jail. When a judge makes that intentional record of that record of intentional detention, he is reversed. And when you look at these cases in the appellate courts always have the same three rationales. They'll say, you can't keep a bailable defendant in jail on purpose using money, because if you can do that, then you've done something dishonestly over here under bail that maybe you could have done honestly over here in no bail. Now that should sound familiar to you, because that was what was written in your Brown opinion from 2014. Or they'll say this: you can't keep a bailable defendant in jail on purpose using money, because if you can do that, you've added an exception to the bail clause. We have the bail clause and we have exceptions to the bail clause. You're adding to the Constitution, and you can't do that. Or they'll say this: you can't keep bailable defendants in jail on purpose using money, because if you can do that, then you've negated the no bail provision altogether. It exists. It's as if it doesn't even exist. So you see the loophole. In America, you can detain anybody you want. You just have to make the right record. That has allowed people in America since about 1830 to be able to ignore what has been in their constitutions articulating who is supposed to be released and detained. You can just ignore them. You haven't had to change them. It's also masked the need for reform, because a lot of people thought, gee, I guess having bailable defendants in jail is a normal thing. And we have all these excessive bail cases saying it's okay. It puts a kind of a legal patina on it. Probably more importantly, realize when we moved the bail system over from England, we wanted to take all the discretion out of it. We based it on due process, fair notice, which is laying down the laws, allowing people to look at them and see how to stay out of jail. But these excessive bail loophole cases have allowed ultimate discretion in, and that's going to make bail reform really, really hard. Because anytime you try to take discretion away from someone in the criminal justice system, it's just really, really hard. If I had to sum up the history and the law together, I would sum them up this way. Bail reform is inevitable. Bailable defendants in jail always leads to bail reform. That's why it's happening now. The use of money, by the way, especially the money used to detain someone, money that results in the detention of someone, is likely going to go away. The federal system recognized this a long time ago in the 80s, took out money and created what I call the big fix, which is an intentional in or out system. But it's been masked and or slowed in the states due mostly to this excessive bail loophole and lately lack of education and some industry pushback. So we talked about the fundamentals of history and the law and what they sort of lead to. Let's talk for a minute about the kind of pressure we're seeing across America, because that's the sort of thing that happens when bail reform works or doesn't work. Remember I said through two different generations of bail reform, the federal system in DC moved from money-based bail to an intentional in or out system, and I call that the big fix. What did the states do? I sort of alluded to it. Every state still kept bail, no bail, either in their constitutions or in 9 states in their statute. But everybody had money in the states. And so they could ignore these things. Money could lead to detention so long as you made that right record. And every single case that anybody ever brought in bail was always decided under the excessive bail clause. It was just natural that judges would decide it under the 8th Amendment. This is changing rapidly now. How's it changing? One way there's pressure to change is there's people flying into federal court right now, and they say, we don't care about the excessive bail clause. We're not even pleading it. We don't care if the guy's in there on purpose or unintentional, intentional. We just don't care. What we care about is the fact that he's in there and there's a money amount on his bail bond. If he's a bailable defendant and he's got money on his bail bond, then what we're claiming is you're violating his due process or equal protection rights. And as soon as they say this, by the way, the defendants in the bail industry swoop in and they say, oh, no, Judge, please. Even though they pled due process and equal protection, you have to decide this under the excessive bail clause. And why? Because that's the way we've always done it, right? And that keeps the status quo. But judges across the country in the federal courts are saying, no, they're asking about due process and equal protection. That's how we're going to decide the case. And you know how they do these things. By the way, due process would be substantive and procedural. The procedural part's pretty easy. It's the part that says he's in there and he didn't have a hearing or any kind of that trappings of procedural due process. That tends to be kind of a slam dunk in the federal courts. But when you're looking at substantive due process and equal protection, even though I'm going to really radically simplify it, mostly you're looking at a balancing test. You know, the court's going to ask the government and say, okay, what are you trying to do? What are your ends? And they'll say, well, we're trying to protect the public and we're trying to get people to come back to court. They'll say, okay, well, how are you trying to do that? What are your means? And they'll say, oh, we're using money. Okay, what's at stake? Well, it turns out liberty's at stake. And once the court decides that liberty's at stake, and there's fights over all these things, of course, then the court will say, well, then we're going to look at using money to achieve those ends under what we call strict scrutiny or a heightened scrutiny. And what that means is the government's going to have to show us not only that these ends are compelling, and that hasn't been a problem. Public safety and court appearance are compelling. But now you got to show us that money is necessary to reach those ends. And that's where it fails. Because to show something is necessary to achieve the ends, you have to almost show that nothing else works. This is where money fails in this balancing test. And so these people in federal court are winning in case after case. I say the things about strict scrutiny because you see this language in every case you see that are in the federal courts dealing it. This first paragraph basically applies these notions of due process and equal protection to a bail schedule. And the judge said, you know, it doesn't seem like it's necessary. She was doing that strict scrutiny analysis. I put this quote up, though, on the screen because more and more, I've seen it now in like 3 or 4 cases. Judges are not only using heightened or strict scrutiny to determine whether money bail works to achieve the ends, but they're also dropping a line that says something like this, and in this case, it was a bail schedule. In fact, the use of such an arbitrary schedule might not even satisfy rational basis review. Now, if you're a lawyer or a judge, you go, whoa, what? Doesn't satisfy rational basis review? That's the easiest possible thing to satisfy. If you have federal judges questioning whether the money bail system satisfies rational basis review, you can almost guarantee that it's heading out the door. The future is more lawsuits, more groups are deciding to sue, more legal theories. I wouldn't have even chosen equal protection as my first legal theory, but they did, and they're winning. The important thing is these lawsuits take away money's ability to detain someone. When that happens, the state is left with this: bail, no bail, limiting process. And of course, that begs the question, in every single state I go to in America, I'll say, okay, if money goes away, what's your net to do intentional detention without bail? What's your limiting process? Are you comfortable with them? I went to one state one time where everything was, everybody has a right to bail except capital offense. And then they said, and by the way, the death penalty is unlawful in our state. Theoretically, they could not intentionally detain anyone if money went away. This happens too, another way of pressure, and I wouldn't have even put this up except that recently Illinois changed. They took all money out of bail and they moved to an intentional in or out process, release detain process, and it was mostly based on these grassroots civil rights group putting enormous pressure on them. I mean, I couldn't tell you how much pressure. They got certain people unelected, they elected other people, they put the pressure on. And it caused this massive change in Illinois. And so I've added this slide saying this could happen too. They didn't really have the same lawsuits that other states have. Now, I could spend a lot of time telling you how money could go away as a detention mechanism, but I want to focus on this one reason that's in yellow. And you'll just have to take my word for it because it's based both on federal and state law. Anytime you decide you're going to do bail intentionally, meaning we're going to make a decision, you're either in or you're out. We're not going to set money and wait around. You automatically are heading down the same path as if you were sued and were told you can't use money to keep someone in. You're heading down that path of having to look at your bail, no bail provision and figuring out whether you're comfortable with them. And showing intentionality is pretty easy. Using an actuarial tool shows a little bit of intentionality because you're looking at defendant risk. Why? So we can release or detain them. Those kind of questions. Doing a detention hearing shows intentionality. Finally, this one's a little arcane, but it's interesting. There are people that are flying into court and they're going in there. And you remember I said that case Salerno from 1987 in the Supreme Court that we used to ignore all the time? It said bail detention laws have to be carefully limited. These people are flying into court and they're picking out a provision in an existing no bail provision in some state constitution, and they're going in there and saying it's not carefully limited under Salerno, and they're winning. There are provisions. I saw one that was 20 years old on the books in a state constitution, been there for 20 years, tossed out because they held it up to that case Salerno and said, yeah, it's not carefully limited. Take my word for it. Almost every no bail provision in America is at risk of a case like this happening. In fact, I talked to the Chief Justice at the time of the Arizona Supreme Court, and I said, you know, technically, by reading that case, your capital crimes exception based on proof, evidence, presumption, grade, that's at risk too. That should theoretically be unconstitutional. And he said, yeah, that's probably true. So if I tell you money as a detention mechanism is going away, and therefore you're going to be left with your bail, no bail process, but your no bail process has big problems, mostly what people are probably going to figure out they have to do is start over. And that means doing a new model. And when you do a new model, you're just asking three questions. Who do we release? Who do we detain? And how do we do it? These are hard. Drawing the line between intentional release and detention can be hard. But you can do it because I did it. And you have to justify it all the way through. You can't just make them up, the groups. You have to have legal justification. So let's talk for a second about the models. Of course, bail the old way in America, in the States, we look at your charge, we throw down some money, we wait around. The new way, we have better ways of assessing defendant risk, we think. We use less or no money. We want everything to be on purpose. And by the way, this is the watchword for this generation of bail reform, intentionality. I would say if I had to sum up this generation, it would be that. But I want to focus on this word risk. And that's because I think it's vitally important that everybody learn the risk research. It's so important. I put a picture of a little super guy on here to remind you how important it is. This is the only real way you can become comfortable with your model, an in or out model, is to understand how risky are defendants, what goes into making these actuarial tools. Should we use them in the detention process? All these questions. I didn't want to know anything about this. I didn't want to have anything to do with it. I'm a lawyer. I don't want to care what the area under the curve is or false positives and all that stuff. But I had some guy come to me and he said, you know what, Tim, you wrote these 2 papers. You wrote Fundamentals of Bail and that other paper on how to set bail. And you said, in order to do the bail the right way, you'd have to change all your laws. I go, yeah, I said that. He goes, well, you owe it to them to write a paper to say what they should change to. And I go, oh, okay, I don't want to do that, but I'll do it. And then I started thinking about it. And at the time, the field was sort of heading in a certain direction. And the way it was heading was they were looking at these things called actuarial tools. And they'd say, well, what we should do is use this tool. And if you're high risk, we'll detain you. If you're low risk, we'll release you. And then I heard all the sort of the slogans at the time. They'd say, we're moving from charge to risk. It's a risk-based system, all these sort of slogans. And I thought, well, this might be the easiest paper I ever wrote. This will be 10 pages. All I'm going to do is I'll go in and tell the states, I'll say, okay, I know what you have now in your law. You have bail and no bail and a further limiting process. But what you should do is get rid of that and say, we're going to release everybody except high-risk people, and we'll use an actuarial tool to determine when you're high risk. That'll be 10 pages. This will be the easiest paper I ever wrote. And then I started hitting the wall. I had big problems. If you say you're going to release all low-risk people, what do you do with that low-risk person who is in on a really high charge? And we call that the son of Sam hypothetical, because son of Sam, who was a serial killer, apparently was assessed by a tool as low risk. And I thought, oh, okay, I got to build that in. Well, what about a super high risk person who's in there on a stealing a candy bar charge? Oh yeah, okay, that's tough. I got to build that into my model too. And that starts to bring up legal foundations, doesn't it? I mean, the essence of excessive bail is that there's going to be some things like stealing a candy bar that maybe you don't need to detain someone for. And I said, oh shoot, I got to worry about all the law. And then this thing popped up once again: due process, fair notice, vagueness. And as you recall, I said due process, fair notice, which the Supreme Court says is the most important part of the due process clause, says in America, we lay down all the laws on the books, both in substantive criminal and in bail. And we tell you, so long as they're not vague, we tell you clearly how to stay out of jail, how to stay out of trouble. And we do that so you can walk freely down the streets and knowing what you can and can't do. It's very important. There's other reasons for the due process for vagueness doctrine, but that's a big one, fair notice. If I tell you we're going to release all low-risk people and only detain high-risk people, what's your first question? Mine would be, well, how do I keep from being high risk? And the answer is, you can't. You're either high risk now or you're low risk now. We just haven't assessed you yet. Or maybe we did assess you and we know what you are, and now we're just watching you. That's a big problem. So the law gave me some serious problems. And then, of course, I started looking at using a tool to detain people, because that's what everybody wanted to do. And I said, well, okay, I could be talked into using a tool to detain someone, but only if those tools are really super tight. I mean, realize we're basing detention on prediction, so the tool better be really tight. And the more I looked into these tools, the more I realized, well, they're just not that tight. So let me give you an example. In Colorado, we have the CPAT, Colorado Pretrial Assessment Tool. And you're either a 1, 2, 3, or 4 on that tool. If you're a 4, that means you're higher risk than a 3, 2, or 1. We don't use the word risk, but you're higher risk than a 3, 2, or 1. If someone's a 4 on the tool, what does that tell me about that person? It doesn't tell me anything about that person. It tells me that he looks like a group of people who, when we assess them, who have similar characteristics, that came out as 4s. But we don't know exactly what he's going to do. He could be perfect, or he could be the worst defendant you ever saw. Well, okay, that's not as tight as I'd like it, right? We call that the individual aggregate problem. I'd like it to be tighter if possible. What does it tell you if he's a 4 when it comes to court appearance? Well, in Colorado, it says if you're a 4, you're higher risk than a 3, 2, or 1 to miss court for any reason whatsoever. They count everything. Well, now, if I'm releasing everybody, that's helpful to know, right? If I'm going to release everybody, I'd say, ooh, I need to know who the 4s and the 1s are because I can spend most of my resources on the 4s. I might be able to make an impact, maybe interview him and find out what his issues are. But detention, we've never detained anyone in America on purpose for missing court for any old reason. We've only allowed detention in America for extreme risk to flee to avoid prosecution. Tools don't measure that. They measure missing court for any reason. All right, what about public safety? Same thing. If you're a 4 on the CPAT, you're higher risk than a 3, 2, or 1 to commit anything from a traffic offense all the way to murder. And again, if I'm releasing everyone, these tools are phenomenal because they tell me that here's the 4. I can work on the 4. Maybe I can put some resources there. But detention, we've never allowed detention for risk to commit any crime. In America, we've only allowed pretrial detention based on prediction for extreme risk to commit a serious or violent crime. That's just the way we've done it historically. So you see, I had problems with the law and the evidence, legal and evidence-based problems. And suddenly my 10-page paper turned into a 220-page paper, but I figured it out. Now I call it model bail laws, but I don't want you to think of the word model, like I said, as being this is the greatest thing ever. This is my model. Now I guarantee you my model is better in one way than every other model I've seen because I have 200 pages of justification for why my template at the end says what it says, and hardly anybody else justifies what they've said. It's a long paper, and so a lot of people said, that's too long, we'll never read it. So I wrote this second paper called Changing Bail Laws. It's a 60-page summary of model. And if that's too long, some people said that too, I have a 15-page paper on the front page of my website that says the biggest issue facing bail today. Now I call it Plan B because I would go around the country and tell states, if I'm right, and if money is going away as a detention mechanism, I'm not saying it's going away completely. It's just that courts are mostly trying to make it affordable. They're saying it can't lead to detention. If that's true, then everybody's going to want to change their models, and you need to start working on Plan B. So I tell states that. And a moneyless model has certain things it has to have. All my research, as you recall, was trying to figure out, can we detain based on risk? And I said, no, I think you still have to have, you're still detaining based on risk, but you can't have this sort of unlimited net. You have to still have a limited charge-based detention eligibility net. So you're still going to have, in the future, bail, no bail, and a further limiting process, even if you call them release and detention. You should realize one of the beauty parts about my model, when you really get deep into it, is you can realize that this further limiting process is really where it shines. I worked on this with 5 or 6 people. We took care of all the problems that we ever saw in any limiting process in any state in America and the federal system. And it's a good one. It takes care of that individual aggregate problem. It takes care of the problem of risk of what. It takes care of all those things. And it can cure a wide net. If you think your net's too wide, this will cure it. This will only focus on detaining the most risky people within that net. But you also need to look at a secondary net and limiting process. What's that? Well, that's what you're used to calling bail revocation. You have it in your law. But I like people to focus it more on, let's think in terms of nets and processes. Secondary net, in my model, happens if you fail to miss court or if you commit a crime. Now, these can be looser, but they're still the same basic thing. You're capturing people that are eligible for detention and you're determining this high risk. A good secondary process, limiting process, can cure a narrow net. So if you think your net up here is too narrow, your secondary net and process can actually help cure that. That's the beauty of the moneyless model that we did. But my point today is I would not have been able to do a decent moneyless model without understanding this risk research. I think you also need to know it to assess whether your current model is something you're comfortable with or not. The risk research tells you a lot of things, but I can tell you right now, it tells me one thing right off the bat, which is defendants are simply not as risky as you think they are. Every time you see a tool and they're high risk on the tool, it's like 75% succeed, 80% succeed, and they call that high risk. They're just not that risky compared to other groups. They're certainly not that risky to do the things that we care about, which is extreme risk to flee to avoid prosecution or to commit a serious or violent crime. And those are almost impossible to gauge anyway on a tool. That's why you have to kind of keep the tool out of the detention process. The risk you're going to assess in detention is different than the risk you're going to assess for release. Now let's turn the corner and go to New Mexico. Let's look at the fundamentals, the pressure and models, and how you guys have fared. Specifically, were you educated in the fundamentals of bail? Absolutely were, from this case here. Now, this is an interesting case to me because I wrote my fundamentals of bail paper and I published it on the 5th of November. And look what came out on the 6th of November. I guarantee you they didn't see my paper and I didn't see this case, and yet the Brown opinion is a fundamentals of bail opinion. I spent most of my time working for appellate judges trying to figure out, and so when I wrote fundamentals, I said, what do I need to know to write a decent court opinion or to write a decent paper so that people can understand bail? And so here we are, two different groups, your Supreme Court and me, working in parallel tracks, and we came up with the exact same fundamentals. And all you have to do is look through the Brown opinion and you see my fundamental one. Why do we need pretrial justice? And the Brown opinion is full of quotes to talk about why we need it. The history of bail, they have 5 full pages of the slip opinion talking about history. Of course, there's legal foundation. It's an opinion. But what's interesting to me most is that the Brown opinion happened, like my fundamentals of bail paper, before any of these federal cases started to happen. That's one thing that's happened since 2014. So Brown is unique in the sense that it used state law to come up with the same basic conclusions that I came up with in my fundamentals paper. Of course, it cites to a lot of the same documents I cited to in the research. And it's cited to the ABA standards, so it's cited to the national standards, the 5th fundamental. And finally, get this, on the very first page of the Brown opinion, it said the Bill of Rights of New Mexico guarantees all persons before conviction. And then it says instead of are entitled to bail, it says are entitled to be released from custody. They switched it out. They stopped the quote here and they went on to say released. That's a use of terms and phrases, which is indicative of knowing the fundamentals of bail. So did you already learn from the fundamentals of bail? Absolutely, from that opinion. Did you have pressure to change? Absolutely. The same opinion put massive pressure on you to change. When I go around the country, I talk about not only the federal cases, but I say, by the way, you might have your pressure coming up from your court system and you don't even see it coming. It could be a case that's being worked on right now by your Supreme Court. And did you create a new model? Yes, you did. Except for a couple things. You started in 2016, you changed your constitutional model. Then you changed the rules, and those all make up what your model is today. But you did all of this prior to have any kind of document that provided any guidance whatsoever. Remember, it took me 1.5 years to figure out that I was heading in the wrong direction. That's why I am so amazed that you guys actually came up with a model that is good. It's not, I mean, it could have been 1,000 times horrible based on what I know about bail, and yet you kind of stayed on track with no guidance whatsoever except for what was out there at the time. If I had to look at it from a distance, and I've kind of looked at it from a distance and knew when it was being done, I was kind of helping behind the scenes in a way. The new model seemed to emulate, in fact, there's a part of the rules that says it was derived from the federal law, which means the big fix, which means it was looking at an intentional in or out release detain system with no money. Money's not allowed to detain in the federal system. So it tries to create that intentional in or out system. And it puts big restrictions on money, but it didn't take money out, did it? It didn't actually completely fix unintentional detention, because there's some loopholes that allow you to use money to detain. So back in 2020, I was asked to come out to New Mexico because New Mexico was thinking about changing the model once again. At the time, they were saying, why don't we put some rebuttable presumptions in there toward detention? And I thought, oh, this is great. This is great for me to come out and now, you know, you already created your model and now I've written my model and sure enough, there's other people weighing in on that. I can come out and go into detail about models and intentional release, detain, and all the things about money I know. And so I handed out all kinds of stuff. I handed out the big fix and my model and all this justification. And I talked about comfort with ness and limiting processes and money. And then I gave excruciating detail. I mean, I was showing drafts of constitutional provisions in New Mexico and how they morphed into other language. And that was too much information. I realized it very soon. So at the time, I realized, well, if I get this chance again, I'm just going to ask a few questions and I'm going to give some main points. And hopefully that's how we'll wind this up today. So here's the New Mexico model from a distance. And I'm just going to ask you, are you comfortable with it? Your net is all felonies. That's your net. Your limiting process is clear and convincing evidence that no release conditions reasonably protect the safety of other person or the community. This is the federal limiting process. It was lifted from the federal law, but only for public safety, not flight. Now, I've written a lot of papers on this limiting process and how I don't necessarily think it's good enough as a limiting process by itself. But that's what you were working with. You didn't have any other decent examples. You were looking probably at New Jersey, which if you have time to talk about, I'll tell you, it was way out there in terms of what they were doing, and the federal system in DC. But it also raises other questions. What about misdemeanors? And every time I saw Justice Daniels after this, and I saw him a lot of times, I'd always ask, how are you doing with those misdemeanors? You know, they're not in your net. Technically speaking, they're not supposed to be in the intentional in or out process. Theoretically, they're supposed to be released. And he always said he's okay with it. He said, that's okay. Doesn't bother me if all misdemeanors are released. That's what he said. What about flight? That's not in there either. And the secondary net in the process, I noticed that they're not in the Constitution. They don't have to be, but they're in your rules and they're really loose. And maybe that was the point, right? I didn't ever ask about that, but maybe having a super loose secondary net and process for when you fail on pretrial release. Remember I said that can take care of a narrow net. Maybe that's what was happening with the very loose net and process. There's still some big loopholes when it comes to money. This word, by the way, in the Constitution, this comes up all the time in bail across the country. Anytime someone says they shall not be detained solely because of financial inability, well, I always get the argument from someone who says, well, they're not being held solely because of inability to post. They're in there because of their inability to post and their high risk. You hear that all the time. That's why those words don't exist in the federal model or in the DC model or in anybody that's done an intentional release detain model in which money is taken out of it. So you have lots of restrictions on money, but in the rules, you know, it still talks about solely and unless. And so basically money can still lead to detention in New Mexico, which puts it at a little bit of a risk for those same federal cases I talked about. Remember I said anybody that's in jail with money bond, detained, we don't care anymore about the excessive bail clause. Theoretically, they could come in and sue based on equal protection and due process. So I'm going to leave you with these main points. Brown is your fundamentals document and your pressure, right? It caused your pressure. It caused you to change. You can certainly read my papers that came out at the exact same time, and they'll fill in some holes, obviously, because my papers are longer than the Brown opinion. Both of them ended 2014. So you want to know what happened beyond 2014. And I'll just tell you this, if you really want to know, there's three things that have happened that are worth noting. One is all those federal lawsuits. So those aren't in Brown or my paper. They probably wouldn't have been in Brown if they were going to stick to state law. Two is a nationwide debate on actuarial tools, pretty kind of going back and forth, and I can weigh in on that later if you need to. And third is this whole notion of these civil rights groups and grassroots groups really getting involved That's something I didn't see coming. That's only happened in the last couple of years, and it's radically changed the way things are happening. So you can read those things up to 2014 and then fill in the blanks. But then I would read my papers that I've written about models in short to long order. First, that 15-pager, biggest issue in bail today. Second, changing bail laws. And then if you need it, if you feel like, oh yeah, I think we really need to look into making big changes again, you can read model bail laws. All they are is applying the fundamentals of bail to creation of a model. And then you just ask yourself, am I comfortable with how we came up with our model? And I think if you read my papers, you're going to say, wow, we did get a lot right. You know, we have a charge-based detention eligibility net. We have a further limiting process. It could have been much worse. But one way to tell your comfort is also by asking two other questions. The first one is just to ask yourself, does anyone anywhere use money to detain a bailable defendant? Or, just as important these days, is there just any bailable defendant at all in jail with a money bond on them? That to me always tells me that someone is uncomfortable with where these intentional lines were drawn between release and detention. And secondly, if you were suddenly told that money could not be used to detain, with no loopholes whatsoever, you just can't do it, would you be comfortable with the rest of your model? Now, one thing I didn't mention yesterday, which I should mention today, which I think is important, is when you do a model of intentional release and detention, it's a line drawing exercise. So think of it this way. Now, if you took money out completely, there would be much more consequence to the line drawing. But because it's not completely out, it's not as consequential. But think about it, if you took money completely out, like I did in my model, you're drawing lines between intentional release and detention based on prediction. So you don't really know what's going to happen. So how does that work? Well, the way it usually works is a group gets together and says, well, let's all agree on the extremes. Who here thinks that first-degree murderers should be eligible for detention? We all do. Okay, we know that. Let's go down to the other end. What about parking tickets? Should anybody ever be detained in jail for a parking ticket? And we don't care how risky they are. They might be the riskiest human being on the face of the earth. Should we simply draw the line and say, no, it doesn't matter if they're risky or not. No parking tickets. Okay, yeah, we all agree to that. So you see, we're drawing lines, and you can see how it gets more difficult the further in you go. Now we're looking at misdemeanors. What kind of misdemeanors? Now we're looking at felonies. Which kind of felonies? Illinois, just a few months ago, got rid of all their money and had to draw those lines. And now there's people saying, wait a second, we would have drawn different lines if it were us. So they're going back and forth about that. So I'll just leave you with that. I'm not going to go through what I did yesterday, which is an interesting exercise of what I would do to change your model. But just realize there's two different things you could do. One is you can leave your Constitution alone and do lots of stuff in your court rules. And the second is if someone decided to open up your Constitution again to make changes, then I would suggest really understanding all the elements of your Constitution and what you would do and your comfort. So you see, we've left lots of time, as far as I can tell. This is my slide that has my email on it. And if you email me, I normally put my phone on there, so I'm sorry I didn't. But, you know, you can call me anytime or email me anytime. This stuff is in flux, you know, this is happening all across America. I spent last week dealing with Texas's attempt to change their constitution. They did it without any education. So you can imagine what it looked like. So now their goal is to bring up the education in Texas so that if they decide to change their constitution, it at least looks better. But feel free from now on to call me, email me, whatever you want to do. And I'm willing to, you know, work through these things. And I've changed my mind plenty of times over the years, so I could change again. So I'm going to stop sharing. We'll open it up if somebody has any comments or questions of any kind.
Thank you, Tim. If folks have questions, go ahead and you can raise your hand or type it into the chat box. I have one or two questions I want to pick your brain on, Tim, but I'll open it up to the group first. It looks like we do have a question on. On high-profile cases where the defendant has a record of failure to appear, are you saying that a bond is not appropriate?
With a record of failure to appear. And a high profile shouldn't make any difference, really. Theoretically, you should, I would think, base it just on the merits of the case, whether he's a high profile person or not. That's just me. If there's a record of failure to appear, see, this is the difference between our models. In my model, when I came up with my intentional release detain model, then I can detain for extremely high risk for failure to appear, but it has to be more than that. It's not just missing court. In my model, we have to show high risk to flee to avoid prosecution. That's the key. And that's simply because I didn't make that up and say we should just make it harder to detain people. I went all the way through the history of American bail and back in the days when we didn't know how to do intentional detention in America. And so we had case after case in the federal and state systems trying to work their way through it. And the one thing they agreed on was that people shouldn't be detained unless the risk was to do something serious. And when it came to the missing court part of it, the serious risk was risk of flight to avoid prosecution. Now, certainly you can show that evidence in my model with clear and convincing evidence of extremely high risk of flight to avoid prosecution a number of ways. Some of that could come from a lot of FTAs in the past. And what kind of FTAs were they? Was he at the bus station with money in the suitcase? That kind of stuff. That's how I gleaned how I would do my model when it came to flight. Now, yours model doesn't necessarily mention flight in the Constitution. So what you're left with is the ability to set a money bond for flight still in New Mexico, right? You can set money for court appearance, but there doesn't seem to be any way to detain someone without money for purposes of flight in New Mexico. Instead, they've just left the money loophole in there. And then you have to deal with that and hope you don't get sued. Does that make sense?
Question. What if the DA says that they are going to file a 5-409 bond? Sometimes they may not file until the next business day.
I don't know what that is. 509, that thing, what is that called?
That is our motion to preventive detention in New Mexico.
So the question is, what happens if he's going to file one?
Well, basically what happens if the DA says they're going to,
Yeah.
and then they don't until the next day. In the meantime, between the time they say they're going to and the actual filing of the motion, should a judge set a financial condition?
Well, I don't know exactly the details, but it seemed like some of that came up before. Your Constitution, as I recall, and I'm sorry, I don't have it laying right in front of me, starts with the district attorney having to make that motion, right, to detain. It's in your Constitution, which is really unique among the states. But it seems to me that in a really good model, once that indicator is met in some way, and I'm just saying, if I were the judge, I would put the brakes on and wait for the motion to come in. You set a money bond, anything could happen.
Well, and I think what I've seen in a couple of the sites that we've worked with, or what we've heard, is, there's a case and the DA says, hey, I'm going to file the motion. I just haven't gotten it in yet, but I'm going to file it. And so every once in a while, you'll see a financial condition come down, really with the purpose to hold that defendant long enough for the DA to file that motion. I think the problem happens sometimes is if the DA decides not to file that motion, we now have someone sitting in custody purely due to a financial condition.
Yeah, well, those are issues you can work out through your rules, I would think. I mean, that's just a procedural issue where, obviously you have to make the motion. I don't think on-purpose detention kicks in New Mexico until the district attorney makes the motion. If someone sets money to hold the guy, then obviously there are legal issues associated with that. Everywhere you go, even in the federal system, that's technically unlawful to set money to hold someone in on purpose. Because of the loophole, you can get away with it by not making a record to detain. But if that kind of thing is happening, where they're saying we're going to file to detain, and then they don't file to detain, then I think you could probably fix that in your rules, or make it so that the pretrial services group gets back to the judge and gives them the new information, that the person's still in there and he was only in there because the DA wanted to file to detain, but they haven't filed to detain, that kind of thing. It seems to me that's not a structural issue, I don't think, so much as something you could tweak with the rules.
All right, Tim, we have another question. And what about the low-risk defendant, at least according to their history, who's accused of something very dangerous? They might not meet the high detention standard, but straight release seems risky.
So low risk that did what? Low risk?
A low-risk defendant, at least according to their history, who's accused of something very dangerous, they might not meet the high detention standard, but a straight release seems risky.
Yeah, and this is where it gets into that notion of, he called him low risk, and yet he said he's done something dangerous. So we constantly have to remind ourselves that there's basically two kinds of risk. There's the risk needed to release somebody and to watch over them and to do things to them as you release them. But then there's that risk that you could detain somebody for. Charge alone has never been a good indicator of any kind of risk. It's always, even when it's in a tool, it's one of about 13 variables that tells you how risky this person is. So when you say he's low risk, but he's committed a high charge, that gets at that same hypothetical I said before, which is, okay, he's low risk, but high charge. In my model, you would have to find additional evidence to lead to his detention beyond charge. And that's simply because charge by itself is just a lousy indicator of defendant risk. Now, it could be that the public thinks the charge is a fantastic indicator of defendant risk, but that's an education question. One of the reasons why this bail reform movement even got started was because charge was just determined to be a bad indicator of defendant risk. And the people that came along with these risk tools said, these are going to be the panacea. This will help with everything. So I don't know. I forget how the nuts and bolts of your detention process work out. But if you have those facts and circumstances that can lead to detention, and I think I remember telling you your process is pretty loose, right? No condition, combination of conditions. That's a fairly easy threshold to make. That even someone who is considered to be low risk in New Mexico, if they committed a felony, could be detained. And it's good to keep those separate. The tool is going to tell you great things, for releasing people. But when it comes to detaining people, you need this elevated sort of risk. And that's why I do tell people to constantly question themselves, am I comfortable with what's going on right now in New Mexico? Theoretically, I'll tell you right now, your net's wide. All felonies is pretty wide, but it's not as wide as it could be. New Jersey is everybody. Everybody's eligible for detention. I personally think that's probably unconstitutional, but I'm not sure anybody will ever sue them on it. How did they do their limiting process with such a wide net? They don't even have it in their law. They use a decision-making framework that they've all agreed on. So it's a handshake agreement that we're going to use a tool to only detain people in this super wide net. That's like the opposite of my model. Now, since my model came out, the people in New Jersey have said, yeah, we think we should do it better. And so I wouldn't be surprised if there are people in New Mexico that now that they've seen my model with all that justification, and now we've got 4 additional hypothetical models on top of mine, that you could learn from that and say to yourself, oh, I think I would do it differently this way. And this is the way you tell, honest to God, if I knew your model really, really well, I'd be better at this, but I'm not. I'm really good at my model. So if you give me a hypothetical for my model, I'll run them through it and say, yeah, he's in or yeah, he's out. And I've never been uncomfortable with the in or the out. But one thing that makes me comfortable with it is because in the back of my mind, I know the risk research. And I know that, more times than not, release is not going to lead to the horrible thing that you think it is. And detention proves itself. If you put someone in jail, they're in jail. You'll never know if they succeed or not.
Thank you, Tim. We have another question from Judge Laney. There's one point I want to make to a question we had a little about the scenario of when someone is before the court and the DA says, I'm going to file, but they may not file the next day or a few days later. We did have a rule change in November that I believe does allow a defendant to be held for, and folks on here would know, for at least 24 hours to give the DA some time to file that motion. And I don't know if anybody on here wants to say how long that is. And then, Judge, we can get to your question.
And tell me if I'm wrong, but part of the thing we talked about in 2020 was the notion that certain judges felt as though there were people that should be detained that the DAs didn't necessarily file a motion on or weren't getting around to it or whatever it was. That was the issue there. And I said, wow, that's really weird. I've never really seen that before. And so as I recall, the rule change allows a judge in certain circumstances to hold them to give the prosecutor time to make that motion. But because it's in your Constitution, technically speaking, once you hit that limit, the judge is forced to treat it like a release order, not a detention, I think.
That's my understanding, unless someone else wants to provide more information. All right, so then a question. In our New Mexico model, we seem to be missing a mechanism to address public safety when a dangerous defendant is charged with a misdemeanor charge. We can obtain them. Our rules state that monetary amounts are only to be used to address flight risk, and the issue of public safety should be addressed with conditions. What conditions can we set to keep the public safe from a known dangerous defendant when detention is not an option?
That's a good question. Obviously, and I'll show you the difference between models. You made a decision when you were drawing lines in New Mexico. You said we can do intentional detention for felons, but not for misdemeanors. And therefore, you could put money on there for flight. And if you don't say anything and make it high enough, of course, he won't get out. And that's a public safety issue. My model, by the way, my net I chose after studying it for a year and a half was violent offenses, because I decided that certain misdemeanors should be held. That was just my model. It's not your model. So if you're asking yourself, okay, they've drawn the line and this is what they want in terms of public safety, what can I do to keep the public safe? That's when you dive into the research and ask yourself, what sort of conditions will keep people safe? And the fact is, the research is pretty scant out there in terms of what you can do. Short of relying simply on the notion that most defendants don't do anything horribly violent when they're out there, you're sometimes left with just using whatever you can to get by, which might be check-ins or which might be all these non-financial conditions. But this tells me, this is the kind of thing that came up yesterday. People were saying, I have a real problem. There's certain misdemeanors that I think should be in. They should be part of this net for the on purpose in part. That shows discomfort with the model. And that means you should really be thinking about a plan B, simply because right now, the best way to obtain public safety for a misdemeanor under your model is to set an unattainable money bond. But I've already told you all the problems with that and how it probably wasn't supposed to be that way. There's other people that know that research better than me in terms of what conditions can actually help with public safety. But the more I learn about it, the more I realize that it's just hardly anything seems to be shown to be all that effective when it comes to public safety. And the saving grace of it all is that hardly anybody who's released commits any kind of serious or violent crime. And therefore, it's not as huge of an issue as it would be as if they immediately got out and went crazy. The thing that you can rely on, though, in New Mexico, which is, it may seem crazy, but I'm used to thinking out of the box. You have your secondary net in process. And if you let someone out who's a misdemeanor, who you believe is incredibly high risk for public safety, but you've decided to release them because you think you should abide by the line drawing, well, realize that you can pretty much detain them in your secondary net, meaning bail revocation, for almost anything. So that's one way to feel better about it. Unfortunately, I've had to write things where I've told people, sometimes when you're doing an intentional release and detain and you're not comfortable with your model and you're releasing people you don't think you should, what are you stuck with? You're stuck with surveillance, the old days of watching somebody because you're worried they're going to commit a horrible crime. I think the misdemeanor issue is a big deal in New Mexico. It's why every time I saw Justice Daniels, I asked him, how's it going with the misdemeanors? And I still ask, how's it going with the misdemeanors?
So, and you may have already answered this question for Judge Laney. It was kind of a follow-up. She says, on one hand, you're saying that charge is a poor indicator of risk. However, the way New Mexico rules are written, charge in the instance where one charged with a misdemeanor is exactly what's used to prevent us from detaining dangerous people.
Oh, charge is kind of a lousy indicator of defendant risk overall. But charge itself, for all these other reasons, legal reasons and even research reasons, is a really sort of a good way of delineating who's in your net. So there's a difference between those two things. So when I was looking at my net, I was trying to figure out how can I justify, because I had people saying, oh, you're basing it on charge. That's wrong. That's not the way we do it. And I said, no, I think legal principles trump the research in this case when they say people need to know based on charge what it is that might land them in jail. So I looked at my net, at the time I tried to figure out a net and I had to justify it. I came up with violent charges because I found some empirical research that seemed to show that certain people charged with violent offenses were at a slightly higher risk, not much, but slightly, to commit another violent crime while on pretrial release. So in my paper, I used like 5 of those studies. But that's just to justify the net. I realized for it to be carefully limited, another legal principle, you have to go inside that net and then determine who's actually the risky people. And you do that in other ways. It's going to be done in a detention process. It'll be done by collecting all that evidence that you're supposed to collect of risk, but not from the tool, because the tool has sort of inherent problems that don't transfer themselves to the detention process. So when you're designing a model, you do have to think about the two things separately of what's my net, and then what do I do within the net, and is it release or detain? You guys made the decision because you were making, like I said, you're kind of splitting the difference. You were making that on purpose release detain sort of line by drawing that line at felonies and leaving misdemeanors over here, but then you left money in, and then you have this really loose secondary net and process. So, there's all kinds of ways to get around certain things, but I think maybe now if you had the benefit of all these other papers, all these other models, you might have done it different.
Thank you, Tim. So I have a question, and it was one that I asked yesterday, having to do with kind of what's swirling before our next legislative session. And when you came back in 2020, it was actually something that you talked about and addressed, was this idea of rebuttable presumptives. And so we do have local New Mexico data that does not support this concept, but there is a lot of conversation about adding into our preventive detention the concept of rebuttable presumptions, and it would really put the burden on the defendant to have to prove why they are not a public safety risk to the community. Maybe if you can talk about one, or what are the legalities of that, and your thoughts about that change possibly happening, at least from a legislative standpoint.
Yeah, it's interesting because when I went back in 2020, we were talking about the same thing. And I think I'm still in the same boat, which is a rebuttable presumption would basically sort of say that in these cases, the burden is on the defendant to actually, do something. My position is always going to be that in your Constitution, you're going to have this limiting process, and that's going to be the way you can detain defendants. It's going to be a process that you can count on if you're a defendant for the government to use to keep you in. And your limiting process, as I told you, was that they got to show clear and convincing evidence and no condition, combination of conditions suffice. If you want to add something to that process, my theory is, and it's a good theory, is that you can't do it without adding it to your Constitution. Because right now, if I'm a defendant, I'm going to be saying, hey, wait a second, what are you saying that I have some sort of burden over here? I'm reading your Constitution. I see the limiting process. You have to prove that no conditions or combinations of conditions suffice. I don't have to prove anything. I just sit back. So one issue you face is where you could put such a thing if you could even do it. Now, back when I came, and then there's the evidence-based part of it. You should, I think Kelly knows it better than anybody. You have to line it up with the research and ask yourself, well, okay, what charges are they for? And is there any evidence out there whatsoever that shows us that those charges need to be treated differently? But when I went out there, it was interesting because someone gave a sort of an argument for them by saying, well, there's sort of the future of bail reform. We see them in the DC law, and they're in the, where else did they say? They said they're in California and somewhere else, Kelly, what am I thinking of? And
Is it New Jersey?
Federal.
Oh,
The
federal.
federal law, so they were part of the big fix, right? Created back in the 80s. And I said, yeah, but DC never uses them. They just don't use them at all. The federal system, one of the reasons why they have such a high detention rate is because these rebuttable presumptions have been treated like irrebuttable presumptions for so long. So it's one of the problems that is actually in the federal system. And so in California, they were part of this thing called SB 10, but that got voted out. So the closest we had to a state that had rebuttable presumptions that I can remember, and that may have even used them, was Virginia, and they recently got rid of theirs too. The future in the bail reform arena is not to have rebuttable presumptions toward detention, always have that presumption towards release, but then to set up a really good structure that's always been legally justified as to your net and your process. If you set up that structure, the rest of it's pretty easy. And I think in my paper, I boiled it down. I got to the end of it in my paper after listing all the research reasons and legal reasons for why I justified my model to be this type of a net and process. And I asked the question, do you need any kind of rebuttable presumptions? And I said, no, you shouldn't use them at all, for all the reasons I pointed out in the last 200 pages. So there's a lot of reasons for not having them. And I think the more you get deep into it, you'll start to see them. And so what I would do is treat it, though, as a signal that somebody is uncomfortable with the current model. So the goal is, okay, what are you uncomfortable about? Let's find out what it is. Is it the net, or is it the process, or is it something else? Someone said, the rebuttable presumptions will make it easier to do a case or something like that. Let's find out what the uncomfort is. And is it something that you can fix in the rules? Is it unfixable in the rules? Is it something you'd have to open up your Constitution to do, even if you wanted to do it at all? That makes sense? But I look at it with both things, legal and evidence. So you do want to also line up that's where you get into this notion of somebody will often say, these charges, we have a rebuttable presumption. And you go, well, what makes this charge different, except that you happen to think it's more dangerous? Because that's where charge gets in the way. There's just not a lot of research out there that equates charge with risk. Like I said, there's enough there that you can create a net out of it. But mostly you're creating a charge-based net based on legal reasons and not research reasons. It's very easy to justify a charge-based net. In fact, it's easy to justify a really wide charge-based net. But in the end, you got to limit it. And that's why this second part is the most important part.
All right, we have another question. Regarding felony public safety cases that are inherently dangerous by the way of their very nature, such as attempted murder, threats, etc., is there any problem with writing, quote, public safety risk or something to that effect in our written reasoning if a monetary bond is put in place? And I would actually go a little bit further and say, I mean, quite simply, Tim, in New Mexico, based on our rules, can we use money to detain? So if it's $100 or $50,000, if a defendant remains in custody purely because of that financial condition, whether it's written in or not, do we run into some problem areas with litigation?
Yeah, money, this is the problem. This all goes into what you need to know to create a proper model. But money for public safety is just sort of not the way to go for a whole lot of different reasons. Money to detain is a different issue, right? Money to detain on purpose goes against Brown. It's against your rules. It's against the excessive bail clause of the United States Constitution. We have at least 2 US Court of Appeals cases that say you can't use money to detain on purpose. So the question is, well, can I use it to detain by use of that excessive bail loophole? And the answer is, yeah, you probably can, because probably if I dug into your state cases, I would find those cases that say, hey, it's just a high amount of money, he can't get out. And that's just the way it goes. But you do run that risk that people will come flying in and say, well, then we're going to sue you, not on the excessive bail clause, but we're going to sue you based on notions of due process and equal protection, which would force you not to be able to use money at all. Well, I was going to say something about.
And I believe that happened in Harris County, correct, Tim, where they just had to release everyone.
Yeah, the federal cases are still looming to the extent that you have anybody in your jail at all with a money bond on them. There's going to be people that are thinking about suing based on these federal notions. Now, you may also have state law that shows, like I said, you have Brown that says you can't keep someone on purpose with an intention, but that doesn't mean you couldn't do it and say, well, I'm going to use it for flight. I can only use money for flight. And in your mind, you're thinking, but it'll keep him in and it'll help with public safety. But you still run that risk that someone's going to come in and sue you on that. Public safety, the money on a public safety thing is tough, simply because there's a lot of different reasons why it might be unlawful. One is it could be expressly unlawful to use money for public safety. And I don't remember your rules. Some rules say you can only use it for court appearance and you can't use it for public safety. It could also be inferentially unlawful, which is weird because it might not mention anything about what you can use it for, but you can't forfeit it for purposes of public safety. Almost every single state in America, definitely every state that has the bail industry in it, does not allow you to forfeit money on a bail bond for a new crime. So if you set money for purposes of public safety, but you can't forfeit it for a new crime, it makes no sense. And now we have actually had at least one federal district court case where the judge said in California, you can't set money on a bail bond for public safety when in your state you can't forfeit it for public safety because that's irrational and therefore it's unlawful. So that's a little glitch that comes up in almost every state where you think about money affecting public safety. The third thing is, if you look at the research, nobody says that money helps with public safety. Even the bail industry research that almost always focuses on court appearance, they'll always throw a line in there and say, by the way, we didn't find anything that shows that money helps with public safety. And that brings up the biggest issue maybe, which is I've seen people make bail bonds at $20 million or more and get out, and then you have that public safety risk all over again. So the thing I would advise places to do is sort of try to realize money's kind of going away anyway, but definitely if you had to move away from money for public safety purposes, you'd be much better off. and ask yourself, what is it I can do to protect the public instead of money? Because it just doesn't work.
All right, so we have about 7 minutes left. If anybody else has any more questions, please throw them in the chat. While we're waiting, I have one last question for Tim. Tim, as you know, as part of our pretrial expansion initiative in New Mexico, we, as part of the essential elements of the NIC model, we're using the PSA. And so a question we often get asked while we're going through the process of implementation is can or should the PSA be used during the determination of preventive detention? We often try to explain to people that would probably not be a good practice, since our PSA matrices all recommend release. And we know from understanding risk that even our riskiest defendants perform when it comes to public safety or court appearance in the high 70th, 80th percentiles. So we ask that it can be used if preventive detention is not granted and there's going to be a release decision. What is your thoughts on it being used during as part of the preventive detention determination?
This is getting easier for me as I get older. I made it kind of nuanced in my paper, but realize that's why I wrote that big long paper. People were using a tool to detain people, and they didn't even care what was in your Constitution. They would come to a place like New Mexico and say, oh, he's a 6'6", detain. And I'd say, can you detain? What's in the Constitution? I don't know if you can even detain this guy. So my paper was written to find out, can we do that? Is that the future? Under future hypothetical law, can we do that? The answer I came up with is no, you should never use a tool solely to detain someone. Now, the reason I said solely is because I came up with some ideas that, well, you know, sometimes if you use a tool, you're mostly going to see that most defendants are not risky. So if you just say solely, you're going to get into a position where it will actually help people more than it'll hurt them in the detention process. Since then, I've decided that it's too complicated to focus on that. And now I tell states, just don't use the tool at all in the detention process. You're still going to be looking at risk when it comes to detention, but you need to come up with a further limiting process that assesses risk that is better than a tool. Because those tools, like I said, they're telling you risk of missing court for any reason. They're telling you risk of public safety for committing any crime. You want your statement of risk that leads to detention to be narrowed down to the things that matter. And you want it to be based on things that the law would say you need to have to make it carefully limited. So these days, I mean, the only part of my model that I do brag about is this further limiting process we came up with, because I think it's key. And one of the key things about it is I say, don't use a tool to detain. Now we had to change the Arnolds, right? They used to train people to detain people on the tool. We had to change that entire battleship, which was heading one direction in America, and we turned that sucker around. And now they don't say that. Now they actually say only use them for release. And that's the proper way to use a tool. You're still going to look at risk when you detain people, but it's a different kind of risk. It's a higher risk. It's the kind of risk you can prove in a court. It's individualized risk. It's all those things.
Thank you. We have, I think, time for one last question. It says, please address defendants with an FTA history or public safety issue whereby they are put on a GPS monitor and they cannot afford it, and the defense argues just for that. And Tim, just so you know, as part of our pretrial initiative, as we work with new sites in our standards and our MOUs with our sites, as we expand, one of our requirements are that defendants won't be charged for any form of supervision. But it's been a practice, including GPS, but that has been a practice at times throughout the state, is putting people on GPS and then the defendant being responsible for the fee.
Anything that leads to detention, whether it's a money bond or the fee for GPS or the lack of a cosigner or almost anything, could be used in the same way that the money bail cases are used to claim a violation of due process or equal protection. If a condition of release leads to detention, you know, automatically you just ask yourself, how can a condition of release lead to detention? It's not supposed to. If it does, you run the risk of the same legal arguments coming back to get you. I'll tell you the truth, when we started this whole thing, And the people called me after 2014 and said, hey, we're thinking about suing states and we're going to base it on equal protection and due process. And we made a decision at the time. I said, oh, okay. And we kind of fleshed it all out. And then the question came up, should we sue on all these other conditions? Because we see all kinds of problems out there is what we think. And I said, do me a favor, just focus on the money first, please, because the money seems to be the biggest issue. Money keeps people in jail. But since then, I've lost complete control over anybody, and I can't have any say. And so now they're suing for all kind of conditions that lead to detention. Once the bailable defendant is in jail, they're claiming a liberty interest, and you got to justify those things. And it's hard to justify GPS because the research is kind of dicey on whether it even works or not.
Well, I thank you very much, Tim. And we have 2 minutes. And as Tim mentioned, if anybody ever wants to reach out to him, he truly makes himself available. I am constantly knocking on his virtual door a lot. And so if for some reason you can't get a hold of him or you aren't able to get his contact information, always feel free to reach out to me and we will get you connected with them. So again, thank you everyone for taking time on a Friday to spend it with us. And we hope to have some future training sessions on other topics. Thank you.
Thank you all. It was an honor to talk to you.